call the third case on this morning's docket. That is case number 103915, Martin Miller v. State of Kansas.
May it please the Court, Chris Alsleger appearing on behalf of the state, and I would like to request 3 minutes of rebuttal time.
3 minutes is granted.
Thank you. At the start, I think it's important that we frame the issue in this case properly. This case comes to the court on a claim of ineffective assistance of counsel. And so the merits of the underlying jury instruction claim are only relevant within the context of assessing counsel's performance and the prejudice prongs of the ineffective assistance of counsel test. And I think that the Court of Appeals' decision below kind of jumped the gun and went straight to the merits of the instruction claim. Now, certainly
you start from a premise, though, coming from the Court of Appeals to here, that the state concedes the instruction is error.
That was going to be my next line. Certainly the written instruction is erroneous. There was an error in the written instruction. Now,
and what changed your mind? You argued in the Court of Appeals that it was a perfectly correct statement of the law, and now you've conceded that it's not. So what changed your mind?
Well, I think the position of the Court of Appeals wasn't necessarily that it was a pristine statement of the law, but it wasn't misleading or incorrect to the point that it confused the jury. And I think what is actually critical here is that the corresponding oral instruction did comport with the law. It comported with an older version of PIC that this court has said was an appropriate statement of the law. And I think that's very significant when you assess the conduct of counsel and the prejudice that could or could not have come from this. Because when you look at the standpoint of trial counsel sitting there in the courtroom, he hears the trial judge read the correct jury instruction. There's no need for him to object. There's nothing for him to object to. Why would he object? He heard the correct instruction. There's also nothing to tip him off that there might be a problem in the written instruction. Because he's heard the judge read the instruction, it sounds right.
Typically, though, in most criminal cases, both defendant and state attorneys have the jury instructions packet as they're being read. Sometimes they read along, sometimes they don't, but the packet of instructions is included as part of the instruction phase to the attorneys.
I have asked my colleagues that do trials, and they say that generally, yes, that's the case. Not always, but generally they have a copy. They don't always read along.
Sure, you don't have to, but typically they have a copy at least. And
the judge is presumably reading the instructions, but with, the attorneys and the judges have gone over these same instructions so many times, and I'm sure that the judge read right past that error because she said the correct word. Because she'd read this PIC instruction so many times. It's like me and my briefs. After I've written them 5 times, I can't find the typos in them anymore because I just go right over. So, but the point is, the oral instruction was a correct statement of the law. And from counsel's point of view at the time, which is how we have to address his performance, there was nothing for him to object to. So it was not objectively unreasonable for him to not object. And even if he had spotted the error in the written instruction, when you look at the State v. Norris case, there's case law to suggest to him that, well, it doesn't matter because the written instruction is secondary. The oral instruction, according to State v. Norris, is the instruction. That's the part that's mandatory. That's the only thing that's mandatory.
Well, I think you have to say that counsel should have caught the mistake at the instructions conference. I mean that before you have the oral presentation, counsel are there in advance and going over things, and something should have been caught there. Then it's different at the oral. I'm having trouble accepting the notion that it's not deficient performance to not be reading those instructions at the same time the trial judge is supposedly reading them to the jury. I mean, I did it in every jury trial I ever had to make sure that what was being said is the same thing that's on the paper. Because what's on the paper is going to go into the jury room.
A couple of points to respond to that. First, we don't know that the error was in the packet that they had at the instructions conference. They didn't actually read through the instructions on the record at the instructions conference. So, for all we know, that the error may have occurred after the instructions conference when the Chambers typed up the instructions for the jury. I don't know. I don't know how that happened. We don't know when and where the error occurred, so that's kind of speculative. And second, while it might be the best practice to always read along when the judge reads the instructions, that's not required, and I don't think that's a necessary requirement of objectively reasonable performance, especially when you're listening and you hear the judge say the correct instructions. Again, I mean, how many times have we all read through something that we've written and we've seen so many times and we missed the typo? But he heard the correct instruction, so there was nothing for him to object to. There was nothing to tip him off that there might be an error, so how can you say it's objectively unreasonable?
My problem, again, and I don't mean to interrupt, but I do. Why should I be different than anyone else on this court? I can't accept the notion that trial counsel doesn't ensure that everything that goes into that jury room is on a list that's supposed to be there and is what it's supposed to be. I mean, we do it all the time. We make sure that an exhibit that wasn't admitted doesn't sneak its way into the jury room. And these written jury instructions are no different than that. And so it's hard for me to accept that this isn't deficient performance, letting something in the room with those jurors, especially something that defines the burden of proof for the state, and not caught.
And I would submit to you that because he heard the judge read the correct instructions, he had no reason, there was nothing to tip him off to that error. And
I'm just saying you double check the next, and there'd be no, that's the same argument as saying there'd be no reason to believe that the clerk wouldn't mistakenly put in an exhibit like a confession and let it go into the jury room when it hadn't been admitted into evidence. I mean, I think counsel makes certain that what goes into the room is what's supposed to be in the room.
honestly, I think with your analogy, you're really comparing apples and elephants there. I mean, you're talking about, essentially a typo in a packet of instructions that everybody in the room missed it. And yet the judge gave the correct oral instructions. And I want to come back to that State v. Norris case, which the Court of Appeals said, looking at our history, the oral instructions are the instructions. The judge isn't even required to give written instructions. It's not a requirement. So, again, counsel would have been objectively reasonable in not really delving into those written instructions when he heard the correct oral instructions from the bench. And again, I mean, we can maybe decide that Norris was wrong, but at the time of this trial, that was the case law. It's still the case law, so counsel would not be objectively unreasonable in relying on that.
Does any of that matter? Does anything that Mr. Manna did or should have done really matter in a practical sense when Ms. Johnson testified that she definitely should have raised the issue?
Well, again, Ms. Johnson was talking in retrospect, in hindsight, and in an ineffective assistance case, we've got to avoid hindsight and put ourselves in counsel's position at the time. And in her position at the time, she's going to review the record as the appellate attorney, and she's going to look for objections first. Well, there's no objection, so there's nothing to tip her off. Then she reads the oral, if you read the oral instructions, it's correct. Again, nothing to tip her off. And then, even if she does notice the error in the written instruction, then there's the State v. Norris case law, which would suggest that the oral instruction controls. So again, it would be objectively reasonable for her to say, well, that's probably not a very good issue.
Isn't that strategy? And do we even get to strategy if she didn't do a thorough review to catch the error?
Well, she did say she read it. Now, regardless of why she didn't raise it, was it objectively unreasonable not to raise it? And I say no, it was objectively reasonable not to raise it because there was no objection, and the case law says that suggests that the oral instruction controls, and with no objection, she's facing the clearly erroneous standard. So, she might very well look at other issues that have a much better chance of getting a reversal than something under the clearly erroneous standard, which is a pretty tough burden. So,
haven't we said that you can't rely on the strategy rationale if the attorney did not exercise that decision making? In other words, if she says, I just didn't see it, then we can't ascribe to her the strategic choice.
Sure, but you still have to look at it from an objective standpoint. Was it objectively unreasonable? And part of the reason she didn't see it was because there was no objection. So, I mean, it wasn't that she just said, I'm not going to look at this transcript. She did look at the transcript. She said she read it. She didn't see an objection, and she read over the trial court's oral rendition of the instructions, which were correct. So I would submit that she was not objectively unreasonable either.
Sorry. Why don't we just accept her statement, I absolutely should have, as an objective evaluation of the situation?
Well, I once had a 1507 case where the defense attorney, he said on the stand, well, he provided ineffective assistance of counsel because he lost the case. Well, I mean, that can't be right. Because after the fact, counsel looks back and says, in hindsight, I should have done this differently. That's not the standard. You got to look at it from the point of view at the time, and was it objectively unreasonable? Because every attorney is going to look back at a case and say, well, I could have done this differently, or I should have done that. I guarantee you, an hour after I walk out of this argument, a light bulb is going to go off in my head, and I'm going to say, well, that's what I should have said to that question. I mean, it happens to all of us. The fact that she looks back in time and does her, after the fact quarterbacking and decides, oh, I should have called this play or that play rather than this one, does not automatically render it ineffective assistance.
But I think the point, counsel, is that she doesn't testify that she made a strategic decision, that she noticed it, what you just said. She noticed it, it wasn't objected to, so that'll be clearly erroneous, I don't want to burden. She didn't testify to that.
Yes.
She said, I missed it.
Okay.
And we really only have, because of the way the district court treated the case, we really only have her statement in the record to look at for a factual determination, because the district court made no other factual determinations because it cut this thing off at the beginning and said there was no error. Now, we all have come here today knowing the district court is wrong on that point. So aren't we left with the testimony in the record that says, I didn't see it and I should have?
Well, you are, but I think that you also have to look at why she didn't see it, and I think that really goes back to the lack of the objection and the fact that the oral instructions were correct. And I still think you have to measure it against an objectively reasonable standard.
Would you agree that at a minimum it needs to be remanded for that determination?
No, I don't think so, because you have two prongs here. You also have the prejudice prong, and when you look at you look at that piece of it, and I guess first I should say that this is not structural error as the Court of Appeals found. This doesn't fall into that rare class of cases. I think that we tried in our best to distinguish this in the brief, to distinguish it from Sullivan v. Louisiana. In Sullivan, the actual reasonable doubt was defined, and it was defined wrong. Here, that was not the case. The reasonable doubt burden was properly defined, and the jury was not misled by that. And if you take the Court of Appeals at the way it viewed the potential error, which I disagree with, but they viewed it as, well, we don't know whether the jury found all three elements or just one element or two elements, and of course that gets you to the Netter case. Netter of the United States has said that failure to instruct the jury on an element of the crime is amenable to harmless error analysis, therefore it is not structural error. And that gets us back into the performance and prejudice analysis of the ineffective assistance.
That gets us back on jury duty.
When you look at prejudice, I mean, the first thing that we have to look at is, first, we're speculating that the jury even read the written instructions. We don't know that, and they weren't told to read it. They were just given the instructions. But we do know that they heard the correct oral instruction. They were in the courtroom, they heard it, it's on the record. So we know that they were instructed properly in accordance with the law. An older version of PIC, but still this court has said it was appropriate. And then the jury never asked any questions about the instructions. They never indicated any confusion. They did ask some other questions, so they clearly were not afraid to ask questions. They knew how to ask questions. But they did not ask any questions about the jury instructions and didn't show any confusion. And also, you can't read these instructions in isolation. You have to look at all of the instructions, and the elements instruction clearly tells the jury that each element has to be proven. So that would cure any of the alleged error or the problem with the written instructions. And I can tell that I am far past my time, so unless there are any further questions, I will sit down.
Any further questions of counsel? Thank you, counsel.
May it please the court, Jessica Cunin representing the defendant appellant Martin Miller. The state is speculating quite a bit as to what defense counsel thought and what appellate counsel thought when they failed to object to the instruction, the challenge instruction in this case. The state says, well, he read or heard the oral instruction and assumed that was correct, and therefore, because the oral instruction was correct, he, felt that he didn't need to read the written instruction, and so that was not objectively unreasonable. And I actually didn't really follow that argument, but I mean, none of that is in the record.
But what our problem's going to be here that the district court cut short the analysis in the 1507 because it made a decision that the instruction was an error, and so it stopped. And we have no other factual findings by the district court. So it seems to me your argument has to be that the record is clear enough, like Gleason, I guess, or Cheatham, that we can go ahead and make the findings we need to make in order for you to prevail. And you actually don't make that argument as I read your brief. Did I miss something? That we have to, that one of our alternatives is that we should remand this case for further fact finding?
No, I don't make that argument. I don't.
So what is it about the record that you think is so clear that we can make the necessary findings both as to deficient performance and to prejudice, and particularly on the prejudice prong when this court's already said the evidence is overwhelming?
Well, first of all, it's a question of law as to whether the instruction is error or not. And I think it's pretty clear that the trial court's finding that the instruction was a correct statement of law is error, and you can reach that.
Well, we know that because they agree with it. So we're not...
Well, that's new.
That part, I know, but that part's done.
Right.
We've now got, I think, mixed questions of law, in fact, as to deficient performance and the prejudice.
Well, I don't, honestly, I don't believe that you need to get to deficient performance and the prejudice prong, because this instruction, as given to the jury, creates structural error in the jury trial, and that's the end of the question. It doesn't matter whether they, what their reasoning was or why they didn't object. There can be no strategic reason for allowing this instruction to go to the jury and for appellate counsel to not raise it on appeal.
But procedurally, that's the only way it gets here, is through the ineffective assistance of counsel, because an erroneous jury instruction is a trial error that is to be raised for the first time on appeal, on direct appeal, and the only way you get us to revisit that direct appeal issue is to say it didn't get here because of ineffective assistance of appellate counsel, and if you're going to use that as the vehicle, then you're going to have to satisfy the two-prong Strickland test.
Well, I think
You're just saying the answers are automatic to both questions. That it's automatically error.
Yeah.
And that can't be justified by a strategic choice because it's such blatant error.
Correct.
And then, in fact, it's so blatantly prejudicial that it answers that as well. It's obviously, you have to use the procedural.
You have to use the procedural mechanism, but the error is so great that it presumes that counsel, and I'm talking about appellate counsel now, performance in failing to raise it, fell below the reasonably competent attorney, and that because it was structural error, it was obviously prejudicial, so that if she had raised it on direct appeal, he would have gotten a new trial.
Why doesn't Instruction 10 inform our decision? Instruction 10 specifically laid out what the state had to prove, and it correctly says the state has to prove each of those elements. So that would seem to contradict the instruction that had the typo in it. So it seems to me that the state has a reasonable question, both in saying, why doesn't that fix the problem? And two, if they read it and they noticed it, they would have asked a question because they knew how to ask questions because they did it in this case. So again, we're getting back to deficient performance and more specifically prejudice. Instruction 10 says what it needs to say, doesn't it?
No, I don't agree with that. I don't have it in front of me, but as I recall, it's the elements instruction, and it says that the following elements must be proven.
And then it lists out the elements.
And then it lists the elements.
And that's different than what was it, Instruction 9, the one where the typo is. That's different than the Instruction 8, but that's different than Instruction 8. So why doesn't that fix
Well, it's different,
the problem?
and so it's confusing, number one. Number two, it doesn't actually set out that the state must prove beyond a reasonable doubt each of the following claims or elements, and then it lists the elements. It doesn't say reasonable doubt. So it doesn't really reach to the level that the reasonable doubt instruction doesn't define the burden for the jury. And I think the Court of Appeals makes an interesting argument that that instruction, when compared to the burden of proof and reasonable doubt instruction, could actually harm the jury's fact-finding, because when it says each of these must be shown, it kind of, if I understand this correctly, if you have a reasonable doubt as to the truth of each of the claims required to be proved by the state, you must find the defendant not guilty. So it sort of reinforces that first line by saying, by using the word each. And it says, the state or the following elements, each of the following elements must be proven. But then you go to Instruction 8, and it says if you have a reasonable doubt as to the truth of each of the claims. So each of the claims must be proven in order to find guilt. Correct. But Instruction 8 says you have to have a reasonable doubt as to each of the claims in order to find him not guilty. So, which is an incorrect statement of the law. So it's sort of, it's very confusing, and I don't think that it cures the error in the written instruction number 8.
And just so I'm clear, I had said Instruction 10 because that's what I wrote down when I was doing this, but it's Instruction 9 now that I'm looking
The
at it.
elements instruction is Instruction 9?
Yeah.
Okay.
How do you reconcile our cases that are plentiful that talk about oral pronouncements being in variance with written judgments, that the oral pronouncement prevails? That's our general criminal law in every state in this country. It is in Kansas. How do you reconcile that when we're talking about prejudice?
I believe you're referring to the oral judgment of conviction or sentence.
Typically, any oral pronouncement that's made from the bench supersedes anything that's written.
Yeah, and my understanding is that's a final judgment, that, the defendant is convicted, or this is this. I'm talking in terms of criminal law because that's what I know.
Right.
And this is the sentence, or or a ruling on a motion to suppress, fact-finding, that kind of thing.
Which perhaps is even more significant than a jury instruction. It could be argued anyway, but go ahead.
So those control over the written journal entry that follows, because they more accurately reflect the judge's ruling at the time. But a judge's oral instructions to a jury, they're not making findings of fact. Number one, she's not making findings of fact. And number two, the written instructions, the jury is the one to consider the instructions.
So it's the opposite in this case? That
It's the opposite.
The written instruction would supersede any oral instruction given by the court?
You know, I don't...
Even
to
though
me, the issue
as Mr. Elzager pointed out, that's what occurs here. The jury hears the instructions. They're not told to read the instructions. I assume they're told they can refer to the instructions, but they're not ordered to reread the instructions.
Well, they are told to, within the written instructions, they are told to consider that these are the instructions that they must review and apply
It
the
doesn't say
facts.
must review.
I don't know if
I don't
it's
think
must
It
or...
doesn't say must review, at least in my recollection.
It's a pick. I mean, I would have to go back and read that, but...
It talks about referring to the instructions if you so choose, at least that's my recollection.
If you so choose, that I don't recall. But it's a pretty, I think it's a kind of a directive, that these are the instructions, you're going to take them back to the room with you, and you're going to apply them to the facts of the case, and these are the law. And even the DA stood up and said in his opening statement that you have the instructions, and these are what you must consider. I don't think it's really the same kind of analysis when you're talking about an oral pronouncement or findings of fact versus a written jury instructions. And the Court of Appeals does cite a number of cases dealing with whether the written jury instructions control over the oral. And I do understand that oral instructions are important and have their value and that kind of thing, but it's just common sense that the jury is going to review the written instructions more carefully. They're not going to remember the oral instructions. They're not going to sit there and go, but she said, the judge said, that the burden of proof was to be considered this way in the oral instructions. And I would refer you to the Atkins case, which the Court of Appeals relied upon. And that's on page 10 of the decision. In that case, the district court described reasonable doubt during the jury orientation in a potentially objectionable way, but correctly instructed the jury at the close of the case, and the Supreme Court found no error. So that disadvantaged the defendant in that case, but they went to the written instructions, which were correct, and said, well, these control. And so there's no error, even though the oral instructions were potentially objectionable. And I do want to point out that the trial counsel said pretty much the same thing as appellate counsel, which is that he just didn't notice the error in the instruction. It wasn't a strategic choice. They had heard the oral instructions and that they sounded fine to him, and therefore he didn't need to review the written instructions. And even if he had said that, that would have been ineffective assistance of counsel, because I do agree that competent practice requires that pretty much you read the written instructions along with the oral, so that there isn't instructions, so that there isn't a deviation, and it can be brought to the trial court's attention.
Is it understood that Mr. Manna got the incorrect instructions or the different instructions than what the court read? Because clearly the court had had a different instruction that it read than the jury received, but did counsel receive the incorrect instruction, or do you know? When you say that there's a duty to read along, which version did he have to read along with?
Well,
Do you know?
so they were all, I'm assuming, I mean, and there's no evidence to the contrary, that they were all given the same instructions. And,
But obviously the court was reading from something different.
Or misspoke.
Misspoke?
we just don't
Perhaps.
know. I mean, we just don't know.
Okay.
And I know that the state continues to argue that the oral instruction was a correct statement of the law, but the Court of Appeals does an interesting analysis of that and does not seem to agree that that's a correct statement of the law.
We've pretty well thrown the Court of Appeals analysis out the window, though, haven't we?
You mean that
On the
part of it?
any, that's how we've been characterizing it. We got a whole bunch of appeals because of the oral instruction, and you've got now 2 decisions, I think, from our court, if not more, that says that that's okay. So I think we have to live with the oral instruction was a correct statement of the law. Don't we? Based on our own precedent?
If in each of those cases, and frankly, I'm not quite sure, the judge instructed the jury that use the word any in both sentences. And that's, if that's true in every case,
But didn't we said it wasn't reversible. We didn't say it was correct. And in fact, wasn't Pick Third changed in about 2004? And when was this trial held? I think the crime was committed in July of 2004, so you would have been in the area of the time frame in which Pick Third was actually changed to get rid of the any, but even before that, we had said, well, wink, wink, it's not reversible, but better practice is to use the different language.
well, correct. I mean, I'm glad that the court is saying wink, wink, because that's certainly what defense counsel was thinking, that at least one of the sentences using the word any was an unconstitutional definition of the state's burden of proof and decreased it. So, yeah, it's not this great, accurate statement of the law. It's always been kind of suspect, but I think there was some fear that there would be so many reversals if the court found reversible error in that old Pick instruction that they would. And the court sometimes said, well, it's not a great statement of the law, but we look at this and we look at that and the amount of evidence and the other instructions and the instructions as a whole will uphold the instruction that was given in this case orally to the jury.
Given that we have in those cases said that even if it's not the best language, it's not reversible, how do you distinguish that from your argument that this is a Sullivan type of error that's structural? What's the difference?
Well, the difference is that I believe the courts relied heavily on the fact that the first sentence in the instruction was a correct statement of the law. And so the fact that this, and I think it was the second, was kind of ambiguous, did not amount to error. But in this case, the court's instruction, written instruction, allows the jury to convict even if only one element is found beyond a reasonable doubt. And then also permits the jury only allows the jury to acquit if all of the elements fail to meet are not proven beyond a reasonable doubt. So there's just no way the jury can apply a proper standard to the facts of the case, and so that there's essentially no jury verdict. There's no trial. There's no findings to review, and that's why it's structural error, because the whole foundation of the trial pretty much falls down, and that's the difference between the two.
Do you have any further questions of counsel? Thank you, counsel.
Thank you.
Connor, do I have any time remaining?
You had reserved 3 minutes.
Well, I want to make at least 3 quick points. First, the case that she cited, State v. Akins, is not the same situation there. The erroneous statement about reasonable doubt came during juror orientation. It was not an oral instruction, and I don't know that Akins addresses the interplay between correct oral instructions and incorrect written instructions or vice versa, so I don't think that's really on point. Second, as to the way that my opposing counsel has characterized the problem or the situation created by these jury instructions, is that on the one hand it told the jury to convict if each of the elements were proven, and also to acquit if each of the elements was not proven. Well, that's exactly the situation that was faced by the Alaska court in Bohannon v. Alaska, which was cited in our brief, and I think the Alaska court did a very good job of assessing that and noting that basically, if that was what would have happened, then the result would have been that the jury was confused or misled, or they would have hung or asked for clarification, and because they didn't, that it is a fair inference that they were not misled or mistaken by the wording of the instruction, and I would just ask the court to refer back to that case. And then finally, ultimately, when you look at prejudice here, this court has already said that the evidence here was overwhelming. I mean, there was only one of two possibilities here. Either Mary died from natural causes, or she was murdered with premeditation and intent. It was one or the other, and the evidence of the premeditated intentional murder by the defendant is pretty overwhelming. And you just got to ask yourself, let's say counsel did stand up and object and correct this one word in the jury instructions. Is there any reasonable likelihood that the outcome of the trial would have been different? No. There's no possible way that the outcome of the trial would have been different, so obviously he was not prejudiced by the error. And if there are no further questions on anything, then I will conclude my
When we made
argument.
the judgment about the overwhelming evidence, though, we weren't considering the written instruction, right?
No, you were just considering the evidence, the overwhelming evidence of guilt, but it still wouldn't have changed anything. I mean, the instruction, it wouldn't change anything. I mean, there's just no possible way that this jury convicted him because Mary died on such and such date in Douglas County. The only way they could have convicted him is if they found that it was a premeditated intentional murder. There's no possibility, given the evidence, that they were confused. It was either an accident or it was murder. It wasn't an accident.
So there are some cases where the defendant's so guilty we don't need to instruct them properly on the law.
That's not what I'm
We're just
saying.
going to get them.
That's not what I'm saying. I'm saying within the context of an ineffective assistance of counsel claim, when you have to look at performance and prejudice, we have to look at the prejudice prong, and it is, in this context, it's not my burden to show that it wasn't prejudicial. It's opposing side's burden to show that it was prejudicial, and you certainly look at the overwhelming evidence to determine if it was prejudicial, and I'm submitting to you that it clearly was not prejudicial.
I'm not sure you addressed, I'm not sure we asked you, not because you failed to do it, but this notion that because the district court cut off the analysis, do you think we have enough of a record to make a decision about deficient performance and prejudice?
Oh, I think you do. I mean, I think, as I've laid out, I think you can look at the fact that the correct oral instruction was given, so there's no, I really believe there's no deficient performance by trial counsel not object when he hears the correct instruction. And then from appellate counsel's point of view, again, without the objection to tip her off, with the correct oral instruction, again, there's no necessary reason to raise that particular issue. But even as you get beyond that, there's certainly enough to look at the prejudice. Again, look at the overwhelming evidence and ask yourself, but for counsel's error, would the outcome of the trial have been different? Is there any reasonable likelihood the outcome of this trial would have been different?
What about on appeal? Let's assume that let's assume that trial counsel, maybe the record's muddy enough that we can't get into that, but we get to appeal, and Ms. Johnson does not raise this issue, but if it had been raised, don't we think an appellate court would have come out with a different outcome?
No, because first, it would have been reviewed under the clearly erroneous standard, which means you're kind of back at the same spot. You have to ask yourself, is there a reasonable likelihood the outcome would have been different? And again, though, you're still stuck.
And you'd say clearly erroneous because there was no
There was no objection
objection
below.
to it.
And you've got
Even though
to
it's a
accept
typo.
that, because
Okay.
that's the position that Ms. Johnson was in. So it would have been under the clearly erroneous standard, so you're really looking at the same standard. Would the outcome have been different? And again, you can't get past the correct oral instructions. Now, she says it's not correct, but this court has said it was that instruction, that the judge gave was legally appropriate. And the Court of Appeals and this court have both addressed it and said it's not just not reversible error, it was legally appropriate, not error. So again, I'm not so sure that a Court of Appeals that had been brought up on direct appeal, that this court or Court of Appeals would have overturned it on that claim, given the standard of review and the correct oral instruction that was there. Plus, you have to look at all the instructions as a whole. Again, you've got the conflict between instruction 8 and 9, where 9 says each of these has to be proven. And again, I would refer you back to that Alaska case, because I think that the Alaska court really nailed it on that.
Any further questions of counsel? Thank you, counsel. Thank you both for your arguments this morning and this afternoon. Take. Assumed you would. Thank you, counsel.